Welcome to csstudents.com, a learning portal for company secretary students. The new Companies Act was approved by the Parliament in the year 2013. Some of the sections of the new Act came into force in September 2013. Majority of sections came into effect from 1st of April 2014. The Ministry of Corporate Affairs has also enacted various rules under the new Act, effective from 1st of April 2014. The new Companies Act has introduced various new concepts in India's corporate laws. One of these concepts is related party transactions. In this presentation, we would try to understand concepts, legal provisions and their impact on transactions. Under corporate laws, transactions with related parties are always regulated. For example, Section 297 of the Companies Act, 1956. Section 297 used to regulate the transactions between related entities. Similarly, Section 295 of the old Act used to regulate the loan to directors or entities related to directors. Institute of Chartered Accountants of India issued accounting standard for the purpose of disclosing related party transactions. But this accounting standard is limited to the disclosure requirements in the financial statement. Under the new Companies Act, related party transactions are comprehensively dealt with. The new Act provides the definition of related parties with respect to a company. It also provides compliances for undertaking any related party transaction. The Ministry of Corporate Affairs have also stipulated the rules, which provide the manner of such compliances. So first of all, the legal background. Section 2 subsection 76 of the new Act provides the definition of related party. This section provides what all relationships shall be regarded as related parties. Section 188 is the main section. It regulates the related party transactions under the Act. Schedule 4 of the Act is also important. It casts a duty on the independent directors to ensure that adequate deliberations are held before approving related party transactions. The Companies Meeting of Board and its Powers Rules 2014 stipulates additional procedural requirements to regulate the related party transaction. We would discuss all the above in detail in the presentation. So, let's start with the definition. Section 2 subsection 76 provides the definition of related party. As per the definition, with respect to a company, its directors and relatives of directors are related party. Then, company's key managerial personnel and their relatives are related party. Any firm where company's director or manager is partner, or any relative of director or relative of manager is a partner. The next category is any other private company. So, any private company where director or manager is a director or member. As we know, with respect to a company, directors and manager are key people. They have all the powers to run the company. They take all the policy decisions for the company. They have most likely chance to have conflict of interest in company's transactions. Therefore, the definition primarily covers directors, managers, their relatives, the firm where they are partners, or firms where relatives are partners as related party, and private company where director or manager is either a director or member. The next category is public company. As per the definition, public company becomes related party if directors with their relatives, or manager with their relatives, hold more than 2% of the paid-up share capital of such company. Then comes any body corporate whose board of directors are accustomed to act as per the instructions of our directors or manager. Next one is any person, as per his instruction, directors and manager of the company are accustomed to act. Other categories: company's holding company, then company's subsidiary company, company's associate company, fellow subsidiaries. All are related parties. The last category comes from the rules. It includes directors and key managerial personnel of the holding company. Let's understand the definition with an example. As appearing on the screen, X Limited is a company for which we need to determine the related parties. X Limited has 3 directors. Those are Mr. A, Mr. B, and Mr. C. We have already seen the definition of related party. So, as per the definition, with regard to X Limited, all the directors Mr. A, Mr. B and Mr. C are related parties. The definition also provides that all the relatives of Mr. A, Mr. B, and Mr. C are going to be related parties with respect to X Limited. So, who are the relatives for the purpose of this definition? Section 2 subsection 77 of the new Act provides the definition of relatives. As per this definition, relative, with reference to any person, means if both of them are members of Hindu undivided family, or if they are husband and wife. The last category is if the 2 persons are related in such manner as may be prescribed. So, under subsection 77, Ministry of Corporate Affairs has the right to prescribe other relationships to be classified as relatives. Accordingly, MCA has prescribed the Companies Specification of Definitions Details Rules, 2014. Rule 4 of these rules provides the extended definition, and, as per this definition, the term relatives means father, including stepfather. So is mother, including stepmother. And the definition goes to include son, including stepson and also son's wife. Then daughter. But if you carefully see the definition, stepdaughter is not included in the definition of relatives. Then, daughter's husband is also a related party. Further, brother and stepbrother and stepsister are also included. This is the definition of relatives under the Companies Act and the rules. Let's revise the same. So, as per the definition given in the Act and in the rules, the term relatives means members of Hindu undivided family, husband and wife, father, including stepfather, mother, including stepmother, son, including stepson, then son's wife. So this would include stepson's wife also. Then daughter. But this does not include stepdaughter. Then daughter's husband. Then brother, including stepbrother. And sister, including stepsister. So, back to our example. Mr. A, B and C are directors in X Limited. All their relatives are going to be the related party for the purpose of X Limited. Now back to the definition of related party. The next category is a key managerial personnel or his relative. So, who all are key managerial personnel, or we say KMP. The definition of KMP is given in Section 2 subsection 51. As per the definition of KMP, key managerial personnel in relation to a company means the chief executive officer, or the managing director, or the manager, the company secretary, the whole-time director, the chief financial officer, and such other officer as may be prescribed. So, as per the definition of related party, KMP and their relatives are also related parties. Let's review the example again. If Mr. Z is the company secretary of X Limited, Mr. Z would be KMP, and he and all his relatives would become related party for X Limited. The definition of relatives is same as we discussed in the previous slide. The next in the definition of related party is a firm in which a director or manager or his relative is a partner. So, take any partnership firm where either Mr. A or his relative is a partner. Such firm would become related party. A director or manager or relative need not be the partners together. Even if one of them is a partner, that firm will become related party. The next, a private company in which a director is a director, or a director is a member, or manager is a director, or manager is a member, means even the holding of one equity share in a private company by the director or manager would make that private company a related party. So, we can say that the mere directorship or membership in a private company would trigger the definition of related party. However, such directorship or membership in a private company is limited to the directors or manager of a company. If such directorship or membership in a private company is held by any relative, then the definition of related party will not trigger. Next comes to the public company. Clause 5 of the definition of related party deals with it. It says that a public company in which director or manager holds directorship is a related party. So, mere common directorship between two companies would make two companies related parties. Next time, if you come across any transaction where your company is doing some business with some other company, where one or two of your directors are common, it's a clear case of related party transaction, and you need to comply Section 108. The next one in line is the body corporate. Before we discuss when any body corporate becomes a related party of a company, let's understand what is a body corporate. Body corporate is a broader term to be used for a separate legal entity. All the companies are body corporate. But there are entities not incorporated as companies, but still gets the status of body corporate. For example, LLPs. LLPs are body corporate as per LLP Act. So, if a director is interested in any LLP, then that LLP would become the related party. Similarly, companies incorporated outside India are also body corporates. By including body corporates in the definition of related party becomes very wide. So, in what case a body corporate becomes related party for a company? To explain, any body corporate would also have its decision-making body. It could be its board of directors, or any committee of members or any managing committee. or that body corporate may have a managing director, or a manager, for its decision-making. If the board of directors, or managing committee, or the managing director or manager of such body corporate, are accustomed to act in accordance with the advice, directions, or instructions of the director or manager of our company, then such body corporate becomes the related party of our company. Let's take the example to understand. X Limited is a company, and Mr. A is one of its director. Now, there is another body corporate, which has two individuals as its directors. And these two individuals are accustomed to act in accordance with the advice, directions, or instructions of Mr. A. Now, the question is, why these two individuals would follow the instructions of Mr. A. The reason. For example, they are loyal servants of Mr. A. And for namesake, they became directors of this body corporate. In reality, Mr. A is running the operations. Or, the articles of such body corporate says that the board of the body corporate would take all the decisions in accordance with the advice of Mr. A. Or there could be an agreement stating these kind of conditions. Under law, reason is not important that why someone is accustomed to act in accordance with the advice, directions or instructions of some other person. The mere fact that the board of directors, or managing director, or manager of such body corporate, are accustomed to act in accordance with the advice, directions or instructions of the director, or manager, of X Limited. Such body corporate would become the related party to X Limited. However, advice, directions or instructions, given in a professional capacity, shall be excluded for this purpose. Other categories. Holding, subsidiary or associate companies are also related parties. In our example, if X Limited has a holding company, then it's a related party. Similarly, if X Limited has a subsidiary, then that subsidiary would also become related party. Or if X Limited has an associate company, then such associate would also become related party. Associate companies are defined under Section 2, subsection 6 of the new Act. The last category in the definition is any other relationship, as may be prescribed. Means, under the Act, MCA has the power to prescribe any other relationship as related party. Accordingly, MCA has prescribed the company's Specification of Definitions Details, Rules, 2014. And Rule 3 of such rules provides the extended definition of related party. As per this extended definition, a director, or key managerial personnel, of the holding company, or their relatives. The last category in the definition is any other relationship, as may be prescribed. Means, under the Act, MCA has the power to prescribe any other relationship as related party. Accordingly, MCA has prescribed the company's Specification of Definitions Details, Rules, 2014. And Rule 3 of such rules provides the extended definition of related party. As per this extended definition, a director, or key managerial personnel, of the holding company, or their relatives, shall be deemed to be a related party. So in the example, now, we are talking about the directors and KMPs of the holding company of X Limited. So with the extended definition given in the rules, directors and KMPs of the holding company and their relatives would also become the related party of X Limited. So, now, we know the definition of related party. In the next part of the presentation, we would discuss the remaining provisions of the related parties. This is the end of part 1. For next part, please visit csstudents.com.